Hello, good afternoon, and welcome to this webinar in our local government webinar series. We'll be talking about legal professional privilege. So by way of introduction, I'm Neil McLean. I'm a partner and I'm head of our local government practice. I'm delighted to be joined today by my fellow partner, Charles Livingston, and our colleague and solicitor, Kiva Hunter-Blair. I'm I'm going to hand over to Charles to properly introduce this session and to, in particular, explain its relevance to all colleagues that have joined.
Thanks, Neil. Okay, so what we're going to cover today, we're going to speak about some of the general principles around privilege, including what it is. We will explain the two categories of privilege, legal advice privilege and litigation privilege, and then we'll say a little bit about exceptions loss and waiver of legal professional privilege. Now, in terms of that point that Neil was just making about relevance to our audience, so obviously this is badged as a local government session. It will be relevant to everybody in local government. We also have people in the audience who are public sector but not local government. It'll also be relevant to you. If you're not public sector at all, it will still be relevant to you with the exception of a couple of slides about FOI. So nobody should feel the need to duck out. And likewise, while it's written from a Scottish perspective, the principles and the case law and everything, there's a lot of cross-border similarities. So if you're in the UK outside of Scotland, don't worry, this session will still be almost wholly relevant to you. So if we start with the question of what is legal professional privilege, it's a good place to start. It's the name we give to the rules and principles concerning the disclosure of evidence in legal proceedings, and in particular, the ability to refuse to disclose evidence in legal proceedings. Those rules and principles have developed under the common law. So the rules are based on the approach taken by courts to cases over decades and even centuries. It is also applied in legislation. So in legislation that contains an obligation to disclose information or an ability of a regulator or other public authority to compel that information be provided, you will almost always see a carve out, an express carve out for privileged material. And that statutory language tends to refer to information that it would be possible to refuse to disclose in court. So even in legislation, it's still generally adopting the common law rule. For Scottish purposes, if you are looking at legislation, you will generally see the term confidentiality of communications. So you'll often see reference to a claim to privilege being capable of being upheld, or in Scotland, a claim to confidentiality of communications. Legal professional privilege is certainly one category of evidence that falls within confidentiality of communications, and it's the main one. So it's the main category that courts may not compel. That concept is a bit wider than just what we're talking about today, but everything that we're talking about today comes within the ambit of that phrase confidentiality of communications, if you see that in legislation. And the courts have held that at common law, privilege and the right to the protection of privileged information is a fundamental principle. And this is something, a concept that Lord Reid in particular has been very hot on since he's been president of the Supreme Court. And that means that only express statutory language will override privilege, and we'll come back to that. A couple of points about the continuation of privilege and essentially the permanence of privilege in most situations. If the privilege arises from a lawyer-client relationship, and we'll get to how and when that would be the case, it continues to exist after the end of that relationship, after the death of the lawyer, and after the death of the client. And that reflects the principle that privilege will remain in existence unless and until waived. So the case Adelcy against Denton's, that was a case where there was nobody living or in existence who had the right to waive privilege in privileged information. And that being the case, the privilege had to be protected because there was nobody around who could waive it. So moving on to the next slide, the question of who enjoys the benefit of privilege. So privilege belongs to the client who commissioned the advice or work to which privilege attaches. That means that it is not a confidentiality right that the lawyer can invoke. So it's the client who decides whether to invoke privilege and whether to waive it. The lawyer is not entitled to prevent the client from disclosing information or to waive privilege in their own right. Lawyer can only waive privilege if instructed to do so. Now, the default, whether we're in private practice or whether you're in-house, would always be to maintain privilege unless instructed to waive it by whoever the right person is to give that instruction. So it's always the client that makes the decision. On the next slide, we covered the concept of joint and common interest privilege, which will be, I think, relevant to a lot of local authority situations, for example, where local authorities are jointly pursuing or possibly even jointly defending litigation. So the principle here is that parties who have either jointly instructed privileged information or have a common interest in it can share it between themselves without destroying the privilege and can each prevent disclosure by the other. And it's that ability to prevent disclosure by others that really makes the difference for joint or common interest. So examples where that arises, if you are joint pursuers or defenders in the same court action, if you've instructed the same representation, then that's probably going to be joint privilege. If you're separately represented, but you're putting forward a common defense where everything is sort of being discussed and it's a collaborative defense, you might describe that as a common interest. It's more or less a distinction without a difference. That's the clearest example, but you also have, if you're doing something with your insurer, for example, in relation to litigation, then the insurer and insured would generally be able to pass privileged information between themselves. Likewise, insurer and reinsurer, partners in a business or joint venture, spouses, and a trustee and beneficiary, those are all thought to have that relationship. Company and shareholder was previously thought to be in that category, but just recently, case law noted there and another case last year have essentially said that that is not the case. The privilege, the joint or common privilege will only arise where work was either jointly instructed or the common interest existed at the time the communication was made. So if one party joins with another at a later stage of litigation, things done before that happened will not be subject to common interest privilege. You might still be able to share privileged information on the basis we'll come back to towards the end, but you wouldn't have a case where each party could assert the privilege against the other. If you have a dispute between the parties, then those parties will each be able to refer to the privileged information in order to defend their own position. So you can't insist on preventing a party, for example, who you have sued from putting forward their defense. If that defense relies on privileged information, you can't assert that privilege against them. Worth flagging that these concepts are English law principles. I do think Scotland is very likely to follow that because the policy reasons for having those rules are very sound. But just observe, the only reference I've been able to find, at least in a recent case, is in Scottish Line Insurance, where the Outer House specifically declined to answer the question of whether a common interest privilege actually exists in Scotland. So an open question, but I think one that's very likely to be answered in the positive that it would exist in Scots law. Just touching on public interest briefly. So this case of Three Rivers, this is a House of Lords case, and Lord Scott's speech in particular is a really good starting point if you're ever looking for an explanation of how privilege works and what it covers, etc. There are a number of cases coming out of that Three Rivers dispute. Number 5 is also relevant. You'll see that come up later. But in number 6 is the one that reached the House of Lords. And on the question of public interest, Lord Scott explained that if privilege is attracted by a particular communication or a particular document, it cannot be set aside on the grounds that some other higher public interest requires that to be done. And a really good illustration of that is the case of Ex parte B, which was a criminal case where somebody charged with murder sought to elicit privileged information that was thought could exonerate them. So there's not much higher public interest than that. But the court decided that the protection of privilege was absolute and it cannot be overridden on public interest grounds. Essentially, the courts have decided that the public interest is served by privilege being absolute, on the basis that if there was any wiggle room in that, then that would undermine the rationale for privilege, and the clients then would not feel as free to share information with their lawyers as they would be where the privilege is absolute. And it's that incentive to share, to be candid with your lawyers, that is protected by privilege on the basis that that serves the rule of law by ensuring clients can get the advice they need to ensure they comply with the law. So I mentioned the sort of fundamental human rights, so the common law principle. There are a few cases there, can only be overridden by express statutory language or necessary implication. So again, we're going back to a House of Lords case. It's a fairly long-standing principle now, Morgan, Grenfell and Co. But recently tested again in Sports Direct International, which upheld that principle, and a recent Scottish example of Scottish Legal Complaints Commission against Murray confirmed it in Scotland as well. The only exception where public interest does apply is in relation to FOI, which we'll cover on the next slide. So you'll know, if you are a public authority, that under FOISA, information can be exempted from disclosure under Section 36, if it's information in respect to which claim to confidentiality of communications, there's that term, could be maintained in legal proceedings. But that is not an absolute exemption. It is subject to the public interest test in Section 2 of FOISA, which means that a requester is entitled to get otherwise exempt information to the extent that, in all the circumstances of the case, the public interest in disclosing the information is not outweighed by that in maintaining the exemption. And that phrasing means that if it's equally balanced, then the tie goes to the requester and they get the information. Worth noting that there is a time limitation on this in a way that doesn't exist in respect to privileged information otherwise. So Part 5 of FOISA deals with historical records, and it says that a record that could be exempted under Section 36 will become a historical record after 30 years, and at that point you can no longer rely on Section 36 to withhold it. But in terms of the public interest test and its application to Section 36, you can get quite a lot of information about that from the Scottish Information Commissioner's briefing, which is summarised on the next slide. Just a few observations on that briefing. I'm not sure when it was last updated, but I think it predates this case of Roche Diagnostics. So the briefing suggests that without prejudice communications would fall within Section 36 as being covered by confidentiality of communications. I think the Roche Diagnostics case makes that untenable now. So without prejudice communications are probably no longer within the scope of Section 36. You might need to withhold them under something else like Section 30, for example, or Section 33. In Roche, the court decided that a party was required to hand over without prejudice communications if it was caught within the scope of a relevant specification, for example. So they were not entitled to refuse to disclose that. Without prejudice nature of the communications goes to their admissibility, not their discoverability. So they are discoverable, but if they are without prejudice, then if the party who's received them tries to put them before a court, then the court will say, no, that's not admissible. But it's two different questions, and it means Section 36 wouldn't apply. Other key points from the Commissioner's briefing: some material on a legal file will be privileged, but not necessarily all. So you can't necessarily just say that everything that relates to a legal matter is privileged. It does have to be a document by document, or in fact, piece of information by piece of information assessment. The briefing does note that there's always a strong inherent public interest in maintaining privilege, even if no specific prejudice would arise from the requested disclosure. And there are a couple of cases there, one from the High Court, one from, I think, the upper tribunal, where the Information Commissioner's decision was challenged, and the court/tribunal upheld the principle that regardless of any prejudice that would arise from disclosure, if you're considering the public interest test as a public authority, you have to place a lot of weight on the fact that there is an inherent public interest in privilege being maintained. So it doesn't just become a harm-based exemption. You do have to think about that. It can be outweighed, even that strong inherent interest can be outweighed in certain circumstances, but you would need a lot on the other side of the scales. And there are a couple of decisions mentioned in the briefing. So the 2010 decision in relation to the Shirley McKee fingerprint scandal, where privileged information was withheld, and the Commissioner really confirmed that there is that strong public interest in maintaining it. But by contrast, a rare example where privileged information was disclosed on public interest grounds is in 2022, when the Scottish Government was ordered to disclose part of its legal advice on a second independence referendum, given the importance of that issue. So that's our FOISA section. If you're not a public authority, everything you can switch back on now. Everything else should be relevant to you. So we're going to talk now about the two subcategories of legal professional privilege. We'll talk about legal advice privilege and then litigation privilege. You can see a quote from Lord Reid in the case of Narden Services about the two concepts. So in broad terms, there's a right of absolute privilege in respect of communications emanating between a solicitor and a client relating to advice. That's legal advice privilege. And also in respect of any documents which were prepared in the contemplation of litigation. Just flag that the protection afforded is the same regardless of which category of privilege you're talking about. The only difference is in how and whether privilege comes to apply to a particular bit of information. So with that, I will hand over to Kiva to talk about legal advice privilege.
Thanks very much, Charles. So I'm going to talk here about legal advice privilege and break it down and go into whose advice is covered and what is covered by legal advice privilege and when does it apply. So generally speaking, legal advice privilege is designed to protect the confidentiality of the lawyer-client relationship, and it applies to confidential communications between a lawyer and client that are for the dominant purpose of seeking or giving legal advice. So whose advice is covered? So the communication must be with a qualified and enrolled lawyer with a practicing certificate, acting in that capacity. So the first two cases on the slide here are two examples where legal advice privilege didn't apply to advice that was given. So in the first example here, it was a lawyer advising as in their role as head of merger and acquisitions, and that was found not to be privileged, even though they subsequently became general counsel for that company. And the second example here is a solicitor acting in their capacity as town clerk rather than in their capacity as a solicitor, and that the advice they gave in that capacity was found not to be privileged. Someone working under the direction of a lawyer who's qualified and enrolled with a practicing certificate would also be covered. And the key thing is that there must be a lawyer-client relationship. The case that's referred to here is an example where the council was found not to be a legal advisor to the community council. And so the communication between the council and community council in this case was not privileged. And legal advice from non-lawyers is not covered by legal advice privilege. So I'll just move on to the next slide here. So what is covered by legal advice privilege? Legal advice privilege covers all advice between a lawyer and a client on any legal issue, even if litigation is not anticipated or underway. The Scottish courts will generally adopt English decisions, despite Scots and English law developing separately and differing on some narrow areas. And the confidentiality of the advice is necessary before the privilege itself will exist. And the two cases that are set out here are examples of when there's a question over the privilege existing in relation to the confidentiality of the communication. So the first one here is an email that was sent by an individual using his IT work systems, and it was found that that could not be privileged against his employer, as there's no reasonable expectations of privacy under the IT policy that was in place in that company. And the other case set out that a reasonable person would assume that the company's right to monitor and access data on its servers would not extend to locating and exploiting otherwise privileged material. And employees are entitled to insert the confidentiality of the material as against the company, and the material in that case remained privileged. So it really is dependent on whether the communications themselves were confidential. Moving on to the next slide about when does legal advice privilege apply? Well, legal advice privilege applies to documents created by a client for the purposes of obtaining advice, as long as it's communicated directly to the lawyer and not via an intermediary. So this is with reference to the one of the Three Rivers cases that Charles had mentioned before. There must be a relevant legal context, and this covers advice on planning inquiries, legislative process, tribunals, and inquests. The information that would give an indication of the advice given has privilege applied to it. So the legal advice privilege can extend to documents that would give a clue or an indication as the advice given by a solicitor. So even if a document does not explicitly state the legal advice that was given, it may still be privileged if its disclosure would betray or show the substance of the legal advice that had been given. And legal advice privilege applies to information and advice given by in-house lawyers and foreign lawyers, although the in-house lawyers it doesn't apply in the EU, but that won't be hugely relevant to our audience today. So moving on to our next slide. So we've covered when legal advice privilege applies, but when does it not apply? It's not sufficient just to copy in a lawyer into communication. That in and of itself won't make the communication privileged. The dominant purpose of the communication must be to seek legal advice. And that's particularly relevant in respect of associated documents accompanying instructions. So the Jet 2 case that's set out in the slide confirms that if the dominant purpose is to obtain the commercial views of the non-lawyer addressees, then the email itself will not be privileged. So even if a subsidiary purpose is simultaneously to obtain legal advice from the lawyers that are copied into that email wouldn't be privileged. So emails are not privileged if the dominant purpose is not obtaining legal advice. However, the response from the lawyer will almost always be privileged. And non-privileged documents do not attract legal advice privilege by virtue of being attached to privileged communications. So if an email is found to be privileged, the attachments to that email will need to be reviewed separately to confirm whether or not privilege applies to those attachments. So who is the client for the purposes of legal advice privilege applying? In the case of Three Rivers, the Court of Appeal defined the client quite restrictively. So despite being heavily criticised and fact specific to this case, the courts have applied the narrow interpretation in a corporate context. So it should be assumed that the client comprises only the employees of an organisation authorised to seek and obtain legal advice on behalf of a corporate entity or an organisation. So any employee who's not actively involved in instructing the lawyer and any employee who doesn't form part of a specially designated unit set up by the organisation to work with the lawyers will fall outside the definition of client for the purposes of legal advice privilege. There is also a risk of loss or waiver of privilege, which we'll come on to discuss in further detail, if advice or summaries of legal advice are shared too widely within an organisation. If there's some doubt about the application of privilege to discussions with employees for the purposes of, so there is some doubt about the application of privilege to discussions with employees for the purposes of gathering information to provide legal advice. So there's three cases set out in the slide here at the bottom. So in the RBS case, lawyer interviews with employees for an internal investigation were considered not to be an exchange with the client, so were not covered by legal advice privilege. But the Court of Appeal has cast doubt on that test in a couple of cases. So there's the SFO case and the Jet 2 case that we previously referred to, but that didn't overturn the RBS decision. There's also a more recent case of the Al-Sadek case, and that appeared to extend legal advice privilege to investigative work. So given there's a lack of a consistent approach in the English courts and that each case is very dependent on the facts and circumstances, the Scottish courts are likely to be able to take their own approach if and when the question comes before them. Charles, I'll hand back over to you now for litigation privilege.
Thanks, Kiva. So the principle of litigation privilege is quite pithily set out in this US Supreme Court quote. Discovery was hardly intended to enable a learned profession to perform its function either without wits or on wits borrowed from the adversary. So what is litigation privilege? There are certain conditions for litigation privilege to apply to a communication or document, and we'll pick apart each of these. So litigation has to be in progress or in contemplation at the time the communication or document is made or created. The conduct of the litigation must be the sole or dominant purpose for which that was done. The litigation or the proceedings must be adversarial, not investigative or inquisitorial. That's going back to Three Rivers, number 6 again. And the communications must be for the purpose of obtaining information or advice in connection with existing or contemplated litigation. So if a discussion is about the settlement of a litigation, as it was in that WH case, of a case involving West Ham, then litigation privilege will not necessarily attach just because they're discussing the settlement of a case, because those communications were not for the purpose of obtaining information or advice in connection with litigation. So litigation privilege applies to documents and communications whether a lawyer is involved or not, and this is the key distinction with legal advice privilege. So it will include things like expert reports, witness statements, and legal advice itself. If it's legal advice, then it may be covered by both. And as I said before, it doesn't really matter how you get to privilege status. The protection is the same. The litigation needn't ever take place. It doesn't. So the threat of litigation doesn't have to be borne out, or the anticipation of litigation doesn't have to have been correct. And privilege will continue to apply even after the litigation has concluded or the threat of litigation has receded. And the litigation in question can be civil or criminal. So we'll start by unpacking the concept of litigation being in contemplation. If litigation has been commenced, that's a slam dunk, that's easy. If it hasn't commenced, it must be reasonably in prospect. There doesn't need to be a greater than 50% probability of it happening, but it must be a real likelihood rather than a mere possibility. And that's a case of USA against Philip Morris and BAT is authority for that. In some circumstances, it will be obvious that litigation is in contemplation. So, for example, if there's a fatal accident, it's a very safe bet to assume that litigation will follow on from that in some sense, possibly civil, possibly criminal. If there's a proactive intimation of an intention to sue, that should be sufficient for litigation to be in contemplation, unless the threat's simply not credible. So let's say you receive a complaint that doesn't include an express intimation of an intention to sue, but there's a suggestion that a claim would be forthcoming if the complaint were found justified. I think that would meet the test of litigation being in contemplation. But if you have a complaint that could never give rise to a claim, even if it was well-founded in every respect, then I'm not sure you could pass this part of the test. There's probably a grey area in the sense that I'm not aware of any authority on this. If you have internal investigations or discussions suggest or even have identified that there has been a failing that would make a claim likely if it was discovered, but there's no reason to suspect it would be discovered, is litigation in contemplation? Then I'm not going to offer an answer because that's a really difficult situation, and that would really have to be fact specific. In terms of sole or dominant purpose, so litigation has to be the sole or dominant purpose of the act or document in question. That's easy if it's something that's been prepared specifically in relation to the merits of a threatened claim or the substance of a claim. So if you have work that would only be done in respect of a claim, the claim is the sole reason it's happened, it wouldn't have happened otherwise, that's easy. It's harder if you have work that would be done as a matter of course in respect of all events or complaints of a particular type. So, for example, if you have an accident of a type that would be investigated in all cases, regardless of whether litigation might follow, then it's possibly harder to say that that investigation is being done for the sole or dominant purpose of anticipated litigation. So things done regardless of the prospect of litigation will usually not have been done with that dominant purpose in mind. This is assessed as an objective question, but the court will have regard to the parties' views at the time. So a couple of examples on this slide. So every case has to be considered on its facts, but there is a high bar. If multiple purposes exist, the courts will set a high bar to establish that litigation was the sole or dominant purpose. So the party seeking to claim that privilege has to establish that it was the dominant purpose. You can see a case there. You won't have litigation as the dominant purpose where an accident would be investigated regardless of any claim. There's law against British Railways as authority for that. Or, for example, the financial position of a company would have to be established whether or not any recovery proceedings were necessary or anticipated. In those cases, the litigation purpose was independent of the other purposes, and the other purposes were dominant or at least equal. However, you will have a dominant purpose, and in the case of high-grade traders, there was a dominant purpose where an insurer was investigating the cause of a fire because their only interest in doing that was to establish whether the insured had started the fire, and if so, litigation would inevitably follow. So despite there being some duality of purpose, the two aspects were inseparable, and litigation was in contemplation even though the report would determine whether a claim would follow. And then a couple of more recent cases on the next slide. So we've got Bilta, where RBS was sent a letter by HMRC about not recovering VAT in respect of certain dealings with Bilta, which was in liquidation. There was fraud allegations and that sort of thing. The receipt of that HMRC letter by RBS changed the scenario from an investigation into a dispute. The HMRC letter was analogous to a letter before action in regular litigation. The RBS team's contemporaneous correspondence and their evidence showed that that was their purpose. They instructed specialist solicitors that indicated their intention to defend the claim. They were gearing up, essentially. The court there said that trying to persuade HMRC not to issue an assessment was part of the continuum that formed the road to the litigation. So it's an inseparable part of that litigation purpose. And that's always a question of fact, and the court referred to taking a realistic and commercial view. Then SFO against ENRC, it's a case that has thrown up loads of privilege points. The court said there is a public interest in companies being able to investigate allegations without having to reveal the results. This apply to local authorities and other organisations. A clear threat of criminal investigation will generally mean there is a dominant purpose of preventing or dealing with anticipated litigation. The fact that legal or regulatory obligations are ultimately enforced by the stick of criminal or civil law means that any alternative purpose of investigating, for example, a corruption allegation for its own sake, that's just a subset of that litigation purpose. And documents aimed at avoiding litigation are just as privileged as documents aimed at responding to litigation. So what can we take from that, and indeed some of what Kiva said in relation to investigations? So litigation privilege will cover investigations so long as the lawyer was instructed for their legal expertise and the investigation is conducted in a legal context. That's a principle from the Court of Appeal in Al Sadek, which we've already mentioned. In terms of investigations, we cannot always guarantee that everything done by a lawyer in an investigatory role is going to be privileged. What we can definitely say is that privilege is much more likely if that work is being done by lawyers than non-lawyers. Documents that are just removed from any legal role or context will not be privileged, almost regardless of the context. The involvement of a lawyer might help demonstrate that litigation was in contemplation and was the purpose of what was being done, but there's a bit less force in that if the standard client practice is always to instruct lawyers to do investigations of a particular type, regardless of the prospect of litigation, or if the lawyer is doing purely investigatory work without a legal nexus. So just in terms of managing that process, it's a good idea to record the reasons for instructing a lawyer and any concerns or intentions, both externally and internally, including marking documents prepared in contemplation of litigation and that sort of thing. But it's important that that marking be genuine. You can't just add that to a document and hope that privilege will apply. Kiva?
Thanks, Charles. I'm going to move on here to the exceptions, loss, and waiver of privilege and take each of those in turn. So there are a number of exceptions to when privilege applies. Legal privilege does not apply if the communication is made for a criminal or iniquitous purpose. So this can include directors' breach of statutory duties, for example. There needs to be a strong prima facie case to conclude that the communication is not privileged. And legal privilege does not apply to contemporaneous accident reports, and it also doesn't apply where it involves destruction or alteration of any evidence. So moving on now to loss of privilege. A party will lose the privilege in a document or piece of advice if they disclose it or its terms to an opposing party, or they've made the document or advice publicly available. Privilege can be lost if advice provided is shared too widely within a client organization, as we've discussed before. And if a party gives evidence in open court on the content of a privileged document or on the terms of privileged advice, they will generally lose that privilege or on the privilege on that document or advice. And so we've got a quote here from Scottish Line Insurance that Charles has mentioned already. So privilege exists in order to maintain the confidentiality of the information in question. It follows that privilege will be lost if the information ceases to be confidential. If, for example, it is published in the press, in such circumstances, there is no longer any confidentiality to maintain, and the information therefore ceases to be privileged. So moving on to waiver of privilege. Privilege can be waived where the party's conduct is inconsistent with maintaining the privilege. So again, referring back to the Scottish Line Insurance case, waiver of privilege can be distinguished from loss of privilege. It will arise in circumstances where it can be inferred that the person has given up his right to resist the disclosure of the information in question, either generally or in a particular context. Such circumstances will exist where the person's conduct has been inconsistent with his retention of that right. Inconsistent, that is to say, with the maintenance of the confidentiality which the privilege is intended to protect. So waiver is determined on an objective analysis of the conduct of the person asserting the privilege. And privilege can be waived for a limited purpose without waiving privilege generally. So moving on to discuss cherry picking. So relying on part of a privileged document or series of privileged documents waives privilege to the rest of that privileged document. Courts can require disclosure of an entire document to assess whether the disclosed part is unfair or misleading in its isolation. So a party can still withhold information that is distinct or severable from the material over which privilege has been waived. So for example, if a disclosed email contains legal advice on one issue, but also includes unrelated advice on another issue, the latter may remain privileged if it can be clearly separated. And courts will allow redaction in some instances where the unrelated content is not necessary to understand the undisclosed or the disclosed part. So if a party relies on privileged material in litigation, for example, quoting from a legal advice letter in pleadings or using it in evidence, this amounts to a waiver of privilege over the rest of that document and potentially any related documents on the same issue. Waiving privilege can also occur outside of litigation. So if the material is deployed publicly, such as in a press release or as part of a preemptive defense of a position, this can amount to waiver too. And in the Scottish Line case, Lord Reid confirmed that there is nothing in the concept of waiver of privilege which requires that the conduct giving rise to the waiver must necessarily have occurred in the context of litigation. Indeed, if there were such a requirement, it would be one which courts have consistently failed to notice. So specifically looking at cherry picking and freedom of information. So referring publicly to the content or terms of privilege advice is likely to waive or lose privilege, as we've mentioned before. So we're looking here at a decision of the Information Commissioner back in 2008, and this related to the City of Edinburgh Council. The question was whether legal advice held by the council regarding the common good status of land was exempt from disclosure under section 36(1) of FOISA. Councillors had made statements at a public meeting and on several occasions about the conclusion of the legal advice obtained. And in the minutes of a council executive, it was set out that the Director of Children and Families advised that legal advice indicated that there was no legal impediment to the use of the golf course and park site for the purposes outlined. In its decision, the Commissioner said, "I'm satisfied that the Council has to a significant extent disclosed the substance of the legal advice contained in the documents requested by Ms. Cairns in support of its position on this matter. I'm therefore satisfied that on this occasion the Council has waived its legal privilege attached to advice sought by Ms. Cairns." So the current guidance from the Scottish Information Commissioner doesn't recognise the concept of cherry picking when it comes to freedom of information requests involving legally privileged information. However, Charles, I've discussed that the decision in 2008 is a correct application, and that the current guidance is either incorrect or just has missed the point here. But as we set out at the start of this slide, referring publicly to the content or terms of privileged advice is likely to waive or lose privilege. And Charles, I'll hand back to you.
Yeah, thanks, Kiva. Just to close off that point, that decision was made by Kevin Dunyan, the first commissioner, and I think subsequent commissioners kind of backed off that approach. And I think that's reflected in the Commissioner's Office of the Scottish Information Commissioner's guidance. But I do actually think that the approach taken in the Cairns decision is, well, it certainly applies the principle, it identifies the correct principle. Cherry picking doesn't have to take place just in the context of litigation, as Lord Reid said. Speaking of Lord Reid, so he noted again in Scottish Line Insurance that you can disclose a privileged document for a particular and limited purpose and will not otherwise lose the privilege. So there's a limited waiver, but you can reassert the privilege in any other context. So a few examples there. Privileged information might be disclosed to the court if the court needs to be satisfied on a particular point. That doesn't then mean that the other parties are entitled to it. The second bullet, there might be a particular point that needs to be vouched for, and privileged information is the way to do that. And that might require disclosing to the other party as well as to the court. But if it's only for that very limited point, the other party, they know it, they can't be made to forget it, but they won't be allowed to rely on it for any other purpose. And indeed, you might even disclose information to a party for use in one set of proceedings without waiving privilege in other proceedings. And the British Coal Dennis Rye case is an example where disclosure in criminal proceedings did not entitle the other party to rely on privileged information in related civil proceedings. You can also waive in respect of one party. So if you disclose privileged information on the condition that it be kept confidential, then you will waive privilege in respect to that party, but you can still rely on it against others, including in order to prevent the party you disclosed it to from sharing it more widely. And the obligation can be either express or implied, and there's an example of each in the cases there. If information is disclosed without authority or by mistake, on the next slide, if it's released by a solicitor without authority, that cannot be used by another party. The Goddard case authority for that. If information is disclosed to an opponent apparently with the authority of the client, so you receive information and you have no reason to think it's been disclosed without authority, but in fact it's been disclosed through accident or incompetence, that's actually quite a complicated situation that we don't really have time to get into. But the Al Fayed case sets out 10 principles governing whether the recipient is entitled to use that information. And the overarching principle is whether it be unjust or inequitable to permit them to do so. The key question is really, was the mistake obvious to a reasonable solicitor? Or indeed, did the recipient in fact know there was a mistake before making some use of the information? If information has been disclosed, very obvious disclosed without authorization or by mistake, it can't be relied on and must be returned, although it would be too late to do that if it's already been relied on before a court. And the final point is that if disclosure is made with authority, then privilege will be waived, even if that authority turns out to have been based on a mistaken belief. So client gets advice from their lawyer that they have to disclose information, and so they say, okay, then disclose it. That privilege is waived even if it turns out the lawyer was wrong and the client could in fact have maintained privilege. So that is a whistle-stop tour of legal professional privilege. I'm happy to take questions, Neil.
Yeah, thanks very much, both. That was excellent and really informative. We do have a couple of questions. I'm no conscious we've only got a minute to answer them, so we'll have to be fairly quick fire. So the first question is about Three Rivers number 5, and the question is, how does the client lawyer employee distinction work within in-house legal teams?
Well, so in-house lawyers, advice from in-house lawyers is as privileged as advice from external lawyers. I don't think that was the point of the question, but just worth being the premise of the answer.
Yeah.
So if the in-house legal team is seeking advice from external lawyers, then the in-house legal team will be the minimum client entity. It may also include others within
Mm-hmm.
the client organization.
Yeah.
If what we're talking about is in-house team relationship with their internal clients, I think the same principle applies. So your internal client team should kind of be dealt with on a need to know basis. You should know
Mm-hmm.
who needs the advice, who's instructing the advice, who's authorized to communicate about it, and kind of keep the exchanges limited to that team. That's the very short
Okay.
answer of how that would work.
Good. Okay. The second question is, how would legal advice privilege apply to preemptive advice in an in-house context? And the example given here is that you're providing advice in relation to develops in the law where a client service has not sought advice directly on the issue from the in-house legal team.
Yeah, so you're just volunteering it.
Yeah.
I mean, I think that's covered. It's essentially like being on if an external lawyer was on a retainer and had an instruction, say, keep us up to date on legal developments,
Mm-hmm.
then there'd be an obvious instruction. I think that's kind of just implied into the in-house role. So I don't think you would need any instruction coming your way in order to be able to give those sorts of updates and have them be privileged, as long as they met all the other parts of the test.
Perfect. Well, thanks so much, and thanks for dealing with those so quickly, Charles. But thanks again to everybody who's attended this webinar. It was so pleasing to see so many people join it. And thanks again to Charles and to Kiva for a really excellent session on privilege. And we hope to see you all again soon.